Hello and welcome back to another video on A-level law. This one is going to cover self-defense, which is a topic in the criminal law paper 1, and it is one that needs to be evaluated in terms of an essay and one that could also come up in a scenario which we'll talk about later. It is a full defence, so if used successfully it will result in an acquittal of the defendant, and the burden of proof is on the prosecution. So once raised, the burden of proof is up to the prosecution to prove beyond a reasonable doubt that it was not done in self-defence, etc. There are multiple reasons why you can use self-defence or force in self-defence. We're going to focus on the top two there, which are defending yourself and others, which are covered by the Criminal Justice and Immigration Act, plus some common law. But there are other reasons, such as defending your property, which is covered by the Criminal Damage Act, and also in preventing crime or making or assisting in an arrest, which is covered by the Criminal Law Act, which we'll talk about later in terms of an evaluative point. In terms of the main test for this, it's looking at the degree of force you actually used, which is covered by the Criminal Justice and Immigration Act. So here we're focusing on the use of force defending yourself or others. Now, the first point is that the defendant is not expected to weigh up the exact amount of force they use, and that's really good because it takes into account that someone's probably going to be panicking or not know exactly what they're doing. And the only question to ask really is, did the defendant do what they honestly and instinctively thought was reasonable? Which is a difficult question, it's a vague question, and obviously people can have different opinions, but it is a really sort of open-ended test, which we'll talk about later as well. Now, if too much force is used, then it is classed as excessive or disproportionate. So that's the terms where actually the self-defense defense would actually fail because the force used was excessive or disproportionate. You can see that in 3 cases, all with a similar pattern of someone running away or in some sort of instance like that. So in Martin Anthony, he was a man in his house called Bleak House actually, and he was terrorised by some youths, and eventually he shot one in the back as he was running away, and the court held that that was excessive force, so he was guilty of murder. He couldn't use the defence of self-defence. Clegg was a soldier at a checkpoint. Some joyriders were driving towards him in a car, and he fired at them. The car turned around, he carried on firing, he actually killed one of the passengers, or the driver. It was one of the people in the car as they drove away, which was again classed as excessive force. Hussein and another, they were tied up by some home invaders. The victims in that case managed to escape, and they chased the home invaders down the street, and they were able to sort of catch one, and they broke a cricket bat over his head, so much so that the cricket bat actually broke into several pieces. And in all 3 of these cases, the force used was carried as excessive force, and they weren't able to use the defence of self-defence. There's no rhyme or reason to this really. It's about just looking at the scenario and making a judgment call. Because of public opinion, the Crime and Courts Act was passed in 2013 largely, and this actually gave a wider defence to householders. There was some concern that people weren't able to use self-defence properly in their own homes, and actually they've changed the law, so essentially you can use excessive force in your home, and that will be classed as reasonable. So for you to fail in the defence of self-defence, it has to be grossly excessive or grossly disproportionate. So it has to be really high level of force that you're using that you shouldn't really be using. And there are some provisos there in terms of the force has to be used while the defendant is in or partly in the building, and D has to believe that the victim is a trespasser. So some sort of interesting area of law there, something you really need to consider in a scenario or an essay. Some other aspects to consider: there is no duty to retreat. So if you have an opportunity to run away, you don't have to take it. You can still then use self-defence even though you had a chance to run away. It does mean that self-defence is less likely to be reasonable, but it doesn't automatically mean no. And we can see that in the case of R.V. Bird, where she had a chance to run away, but then she used self-defence against her boyfriend, who was pinning her up against a wall. Preemptive strikes, you can hit first. That can be acceptable self-defence if you genuinely believe that they're going to hit you first. So we saw that from AG's reference, which was a bit of a weird case for that, but it's the case concerning he made petrol bombs to defend his store in a riot, which doesn't quite work in terms of the normal preemptive strike you'd think of as someone punching someone first, but it justifies it as a precedent. Mistaken use of force, so if you make a mistake, that genuinely, it's fine as long as you genuinely believe the situation to be as it was. So in Williams, he saw what he thought was someone attacking youth. Actually, it was a plainclothes police officer that was actually trying to stop or arrest the youth for mugging somebody. So he grabbed this guy and pulled him off the teenager, and that was obviously a mistaken use of force because he genuinely believed the situation was as it was. That was appropriate self-defence. You can't make a mistake though, an intoxicated mistake. So if you voluntarily take alcohol or drugs or get intoxicated, you can't. If you make a mistake about the use of force you use or anything like that, you can't use self-defense, which is really based around public policy. We'll talk about that later. And also the defendant's characteristics are not relevant to the amount of force used in self-defense. So just because someone's got psychological problems or anything like that, as we saw in Martin, it won't be considered largely in terms of whether it was acceptable self-defense or not, which seems a bit harsh, but we'll talk about that later when we talk about the evaluation. In terms of the evaluation, actually, in terms of the jumping off points, so where you're going to talk about them, so obviously you want to develop each of these. One of the big ones is competing moral principles and the fact that they're contradictory. So on the one hand, we're saying, oh, it's really bad that, it's a criminal offence to hit somebody or anything like that, so violence, battery, assault, ABH, GBH, etc. But you can use violence to defend yourself or defend your property and things like that. So there is some competing moral principles there. Obviously, from a moral perspective, it's really age-old defence, self-defence, and the fact that you should be able to defend yourself and your property and your kids and your family and your friends, etc. But it does seem a bit contradictory there that you're able to use violence to defend yourself against violence. So whether we've moved on beyond that in terms of becoming a civilised society, probably not really, because it's still necessary in many circumstances to defend yourself. If you look at the police use of firearms against terrorists in London and things like that, you can see sort of self-defence really clearly there. There are problems around excessive force. Obviously, it's an all or nothing defence, as we saw in Hussein, where they'd just been tied up and they chased this guy down the street. To some extent, understandably, what they did, but they said they did excessive force. So they were charged with ABH or a non-fatal offence in the end, which does seem a bit unfair. The fact that Martin was charged with murder and convicted of murder, we can look at the situation and go, well, actually, we kind of understand it, and we might not fully understand. So there's a question there is, where it's not a full defence, could it be a partial defence? So should Martin, for instance, have been charged with or convicted of manslaughter instead of murder? Does it seem a bit harsh? The impact of public opinion. Obviously, self-defence is a very controversial topic. People think they should have the right to self-defence, quite understandably, and that probably partly led to Crime and Courts Act, which gave a wider defence to householders, which was something the media at the time were particularly demanding. As I said, it is unfair that defendants' characteristics are not taken into account. So Martin, who had psychological problems, was clearly not able to rationalise or use the same level of force in the instance that someone else might, but according to the court that wasn't relevant. So there is a question there as to whether it should be. There has been some doubt cast on that recently in terms of some of the law passed around loss of control and things like that, but we will wait and see really as to whether that area of law changes. It is difficult to expect juries and magistrates to put themselves in the shoes of the defendant and decide what whether the defendant did do what they honestly and instinctively thought was necessary, especially if you've never been in a situation like that. Someone burgling your home and then you have to use self-defense. It's very hard to say what you would and wouldn't do. So that's a difficult one. Obviously, the big question is, what is reasonable force? The fact that you're going to get inconsistent decisions then, and that can lead to uncertainty. Lots of problems there in terms of just a very subjective term. What does reasonable force even mean? Does the law need consolidating? Obviously, as I said at the beginning, you've got the law which is found in the Criminal Justice and Immigration Act. You've also got law found around the defence of property, in making an arrest, preventing crime, and it's all found in different acts and lots of different common law. So the question there was the Criminal Justice and Immigration Act 2008 a missed opportunity to consolidate the law, or could they have not done it then? And if not, could we do it now and put the law really clearly under one place, bring in the Crime and Courts Act and bring in all the common law and bring in all the areas of self-defence into one place? Number 8, is it fair that drunken mistakes are not allowed? There is a question there, as it seems a bit unfair, because obviously most people make the mistake when they're drunk, and it's genuine in the same side really, but public policy reasons around sort of discouraging people from drinking and getting into fights and things like that are really strong there, and obviously fits the law around intoxication as well. Number 9, it's really good that D is not expected to weigh up the amount of force used, and that's a really big improvement in the law really, and the fact that they're recognising that people aren't thinking rationally in these situations, and that's a really big positive. And number 10, there are some issues around preemptive strikes and when that's acceptable, and AG's reference as a case example there is not the greatest example in terms of using the petrol bombs, because they said it was a preemptive strike in making them, but surely he'd never have been able to use a petrol bomb to kill a rioter. That would have seemed as excessive force in all examples, you would think. In terms of scenarios, obviously self-defense could come up by itself. It could come up in this where you've got a couple of situations in which you have to decide whether the person could use self-defense. That's absolutely likely. The other opportunity or possibilities are that it could come up with a non-fatal offence or multiple non-fatal offences, or with murder as well. So you could have a situation where you've got a murder and then you've got to question whether it's murder, and then also whether they could use the defence of self-defence, and also whether perhaps, and then also another scenario where perhaps you might have non-fatal offences. And then you could have obviously the defence of self-defence there as well. So it could be 1 or 2, possibly 3 non-fatal offences plus the use of self-defence. In those scenarios, obviously the best way to do it is to obviously cover the offences first, cover whether they would or wouldn't be guilty of those, and then cover whether they could use the defence of self-defence or not. And that's the sort of structure to it. I hope you found that useful. It's a quicker video than normal because this is a smaller topic, and there should be more videos up soon. So again, please subscribe and like the video, and leave any comments if you'd like to see anything particularly. Thank you very much.